Good afternoon. I'm Grimes Creasy with the law firm of Johnson, Ayers & Matthews, located in Roanoke, Virginia. And today I will be talking about recent legislative changes that were enacted by the General Assembly here in Virginia, which took effect July 1st of 2017. A number of the changes that have been enacted not only deal directly with the Virginia Residential Landlord and Tenant Act, but also deal with the civil procedure rules governed by 8.01 here in Virginia. I will start and I will cite to the various code sections that have been amended, and then we will discuss the implications of those amendments and how we anticipate these changes to come about. They were or have taken effect as of July 1 of this year, so this is now the current law in Virginia as of 2017. To start with the first amendment that I have cited in my outline, that is Virginia Code Section 8.01-129, that deals with appeals from judgment of general district courts. To give you a little bit of background with regard to this particular amendment, there was a time a number of years ago that when a prevailing landlord/plaintiff prevailed in their unlawful detainer action, the defendant, the non-prevailing party, as all non-prevailing parties in general district court here in Virginia, have an automatic statutory right of an appeal to the circuit court, provided that they note the appeal and perfect the appeal within 10 days of the order of possession being entered. Now, a number of years ago, the plaintiff/landlord would not be permitted to obtain a writ of possession from that order of possession until that 10-day appeal period expired. A number of years ago, in response to some movement afoot, if you will, with the landlord section of the lobbying community, they were concerned because a number of folks would not show up for the return date when the unlawful detainer case was scheduled to be heard. And even though they did not appear and the prevailing plaintiff was able to obtain a default judgment, they still had to wait the 10 days. And the concern among the landlord community was that they were losing rent when they could quickly get an order of possession, retake possession, and put the unit back on the market and avoid losing too much money in the interim. So the General Assembly listened to the concerns of the landlord community a few years ago and allowed for what has been termed a right of an immediate possession. And what that means is that even though the 10-day appeal period is still in effect and would not be altered, nonetheless, if the landlord was the prevailing party, in limited cases, the landlord could ask for an immediate possession or an immediate writ, which would allow for the landlord to literally walk from the courtroom into the clerk's office and obtain a writ and begin the eviction process, even though the 10-day appeal period was still in effect and was still available. Now, I said limited cases, and what that was is that the General Assembly carved out two limited situations in which a landlord would be permitted, if he or she prevailed, to obtain a writ of immediate possession, or an order of immediate possession. And those two limited cases were dealing with non-payment of rent or an immediate non-remediable, which we typically call the 72-hour notice. And an immediate non-remediable in Virginia concerns situations where there is action or activity by a tenant or a tenant's guest that are an immediate threat to the health and safety of the community, for example, drug-related activities. So if you had a non-payment of rent case, or if you had an immediate non-remediable case before the court, and the defendant failed to appear so that you obtained a default judgment in those two cases, you were permitted to ask the court, in addition to any other relief that was available to you, you were permitted to ask the court for an order of immediate possession, which would allow you to then, as I said earlier, go from the courtroom literally to the clerk's office and obtain your writ of possession without having to wait the 10-day appeal period. The General Assembly, as of July 1, 2017, has expanded the opportunities available to the prevailing party, in most cases the landlord, or it typically would be the landlord, in an unlawful detainer case. They've expanded the opportunity or the availability of the immediate writ of possession. Now the way it reads is that in any case of default, so the way I interpret that to mean is if it's an unlawful detainer action, no matter what the breach constitutes. In other words, it could be a non-payment of rent case, it could be a repeat violation case, it could be a 2130 material noncompliance case dealing with noise or disturbance, or it could be the traditional immediate non-remediable, whereby it's an immediate threat to health and safety. It can be any unlawful detainer action if it is a default, which in Virginia means is that the defendant failed to appear at the scheduled return date. Any case of default will allow the landlord to ask for immediate possession, which again, as I just explained before, you had to have two components. It had to be non-payment of rent and a default, or an immediate non-remediable and a default. Now it could be any case of default dealing with an unlawful detainer action will entitle the landlord to ask for immediate possession. Now, a couple of these have not changed, and that is the second category is any arising out of a trustee deed following foreclosure, and we'll talk about a few amendments with the foreclosure actions in Virginia in just a couple of minutes. But right now, that is a case that would entitle the prevailing plaintiff to ask for immediate possession. The third one is ask for immediate possession. Well, the change here, as I mentioned earlier, is you also had to have a default with those two components. Now it appears that even in a case of non-payment of rent or an immediate non-remediable, whereby the defendant / tenant actually appears, and so that is not a traditional default. Actually, they appear and either admit owing the money. It would not, if it were a contested case, it appears that the landlord would be still permitted to ask for immediate possession if they prevail in the case, even though it's not a default. So that's a little bit of a change there. So to break down these four opportunities one more time, if you are the prevailing party, you are the plaintiff, and then obviously it would be the landlord seeking possession in an unlawful detainer case. If you have a case of default, meaning that the defendant failed to appear, regardless of what the basis of the breach was, again, it could be non-payment of rent, immediate non-remediable, 30-day non-remediable. If any case of default will entitle you to request from the court a right of an immediate possession. Also, number two, any cases arising out of a trustee's deed following foreclosure. Any non-payment of rent cases, which again does not require the element of default. So it would appear that if you have a non-payment of rent case, even if the defendant appears, shows up at the return date, the court finds in the plaintiff's favor, the plaintiff would have an opportunity to ask for immediate possession. And then the fourth and final one, again, is the immediate non-remediable lease violation, threat to health and safety, or immediate threat to health and safety. Again, it does not appear that default is necessary in order to seek an order of immediate possession, even if the even if the defendant appears. So those are your four categories: any cases of default, any cases arising out of a trustee's deed following foreclosure, any non-payment of rent case, or any immediate non-remediable lease termination case. All will allow the landlord to request an order of immediate possession, assuming that the landlord prevails. So those are the changes. Now, to level the playing field, as I mentioned in my outline, what the General Assembly has recognized, that even if you do obtain your writ of possession on that very same day, so you did not have to wait the 10-day appeal period, the writ will not be issued or executed within that 10-day period. And of course, if the tenant notes and perfects his or her appeal within that statutorily required 10-day period, that certainly would negate the writ, which it always has. Even if you had obtained a writ within that 10-day period, let's say you obtained the writ on the 4th day of that period, and on the 10th and final day, the defendant noted an appeal, then that would obviously stay the writ and the case would be removed to the circuit court. Backing up for just a second, the first component that I mentioned to you, which said that the writ being issued would not be executed until the expiration of the tenant's 10-day appeal period, well, practically speaking, that's what was going on in Virginia anyway. In other words, the sheriffs, or many of the sheriff's departments that I deal with out in Southwest Virginia, understood that 10-day appeal period. So even though we may have obtained a writ of possession on the very same court date because the court had afforded us an immediate or an order of immediate possession, even though we obtained the writ on that first day, many of the sheriff's departments would still wait and schedule the actual eviction for a date after or the expiration of the 10-day appeal period. So the General Assembly has now codified that, but that was really more like a codification of what was actually going on in the sheriff's department already. But those are the two additional changes to that statute, that any writ being issued from a court's order of immediate possession shall not be executed until the expiration of the tenant's 10-day appeal period. And if the tenant perfects his or her appeal within the statutorily required 10-day appeal period, that will then negate and stay the writ as well. Now, moving to the one, which would be notice to tenant in event of foreclosure. There has been somewhat of a change of July 1 of this year. If you all are familiar, a number of years ago, President Obama executed an executive order that changed the rules somewhat for foreclosures. He did this in response to the explosion, as you all may well remember, from the 2008 market collapse, and there were a number of foreclosures all over the country, and people were being displaced right and left, many of whom were paying their rent, and it was the landlord who had taken out a promissory note, bought some rental property, was then renting or leasing that rental property to individuals. It was the landlord who was actually defaulting with the bank and having his property foreclosed upon. Of course, then the bank would step in, or someone who bought it foreclosure would step in and then quickly evict any of the tenants who were residing in that foreclosed upon leased property. And so a number of people were being displaced, many of whom were really not at fault. They had been paying their rent legitimately and religiously, and unfortunately it was the landlord who was in default, which resulted in them losing their housing. So in response to that, President Obama had entered an executive order which changed somewhat the rules of foreclosure. Let's talk about those for just a second. Typically what happens is if someone defaults on a promissory note that was secured by a deed of trust, as you know, many times people will purchase property, purchase real estate, they will borrow money to do that. The property will secure the repayment of the note. It will serve as the collateral on the loan. In the event that the borrower defaults on that loan, then the deed of trust will allow for the lending company, the bank in many cases, to step in, foreclose on that property, and wipe out, in the act of the foreclosure, it will wipe out any of the inferior liens that are existing on that property. It will also wipe out any of the inferior contracts that may be encumbering that property. So typically what happened was, and then just to back up for one more second, the banks are typically not going to loan money on real estate that's already encumbered by a pre-existing lien. So in most cases, the bank is going to be sitting in a first lien position. And by sitting in a first lien position, if they are required to go through the process of foreclosure due to a default by the borrower, then being in that first lien position, the bank would effectively wipe out, again, any inferior lien positions and any inferior contracts that were encumbering that property. So typically what happened would be that the borrower / landlord would default on a note, the bank would foreclose on the note, and then wipe out any inferior liens or any inferior encumbering contracts, which typically was a lease agreement. And what then would happen is once the bank or someone who bought at foreclosure became the title owner through foreclosure, they would step up and tell the individuals residing in the leased premises that they would have to leave, that the property had been foreclosed upon, which wiped out everything, right of occupancy, any inferior liens, etc., which entitled the bank to literally leave from the courthouse steps where the foreclosure took place, knock on the door of the leased property, tell the tenants that they would have to leave, and typically they'd give them like 72 hours to vacate. If the residents didn't, then the bank or the person who bought at foreclosure would be permitted to file an unlawful detainer action here in Virginia, go into the proper general district court, typically sitting in the jurisdiction in which the leased property is located, and get possession, and obviously get an opportunity through that order of possession to get a writ and have the individual / tenants removed. To step just a second away from foreclosure for a moment, Another scenario whereby ownership gets transferred is if someone buys property that is encumbered by a lease. And here in Virginia, if it's a non-foreclosure type of deal whereby the property is encumbered by a lease agreement and a buyer buys the property from the seller, then the buyer would buy subject to that lease. So the lease would simply be changed hands from the prior owner to the subsequent owner. And therefore, the buyer of the real estate would be subject to that lease agreement that pre-existed and was encumbering the property. Now, I hope I'm not confusing you on this point, but to go back to what President Obama was trying to do is, instead of allowing the traditional foreclosure rules to continue forward and thus defaulting borrowers were effectively dispossessing all of their tenants, President Obama's executive order changed the rules, and therefore those who bought through foreclosure it was more like they were buying straight up as opposed to through a foreclosure sale. In other words, it was more like what I just described, where you buy property that's previously encumbered by a lease and you're buying subject to that lease. So what the General Assembly, fast forwarding to today, what they have done in 55-225.10 is they have, in many respects, adopted what President Obama's executive order had allowed for a number of years ago. And by the way, that executive order had a sunset provision and it expired a number of years ago. But as of July 1 now in Virginia, if you have a foreclosure, that will terminate the lease agreement, which is still fairly traditional. However, the tenant will be permitted to remain in possession of the dwelling unit, even though the lease that was encumbering the property, that was between the tenant and the former defaulting borrower / landlord, that is now, even though the lease is technically terminated, it still is going to afford the tenant the right to remain in the leased premises on a month-to-month basis. Therefore, if the bank forecloses or someone buys at foreclosure, they will buy subject to that lease agreement. Now, the lease is terminated, but the tenant still has a right of occupancy on a month-to-month basis. Now, what will happen here, according to the amendments, is that if the landlord wants to, or what they would call the subsequent owner, the one who bought through foreclosure, if they want to terminate the tenant, the pre-existing tenant's right of occupancy, they're on a month-to-month basis. So what they would have to do is give that tenant a notice in accordance with the terminated lease or in accordance with Virginia law. So if the terminated lease required a 30-day notice to be given to the tenant, then that's what the subsequent owner who bought through foreclosure will have to do. If the lease is silent as to how to non-renew, then Virginia law says if you're in a month-to-month tenancy, then the tenant is entitled, or the landlord is entitled, to a 30-day notice given at least 30 days prior to the next rent due date. To give you an easy example, today is July the 25th. If I gave you a 30-day notice to terminate a month-to-month tenancy under Virginia law, then you would have until August 31st to vacate, because I would have to give you that 30-day notice at least 30 days prior to the next rent due date. So the way this will now work is the borrower has defaulted, the former landlord is out, the new purchaser or new owner, either it's going to be the bank or someone who bought from the bank in foreclosure, is going to be the subsequent owner. They're now going to be the title owner to this property that they bought through foreclosure. The tenant who was living in the real estate and was paying to the former landlord, that tenant's lease will be terminated. However, they will still be entitled to possession unless or until the subsequent owner, the purchaser through foreclosure, gives that tenant a 30-day notice to vacate or a 30-day notice to terminate the lease. Now, the tenant who is in the foreclosed upon property is still going to be obligated to pay the rent as called for under the former terminated lease. And that tenant will be having to pay that rent to the new owner, to a managing agent of the new owner, or if they don't know to whom they should be making their rent payments, they are permitted to make that payment into the court. and they would ask the court to set up an escrow account in which those rent payments could be made until the new owner, the subsequent owner, the purchaser through foreclosure, steps up and directs payments to be made to them. So that is somewhat of what I would think, a significant change to foreclosures here in Virginia, such that the old, somewhat draconian way of the landlord or the buyer through foreclosure, who steps up and buys in foreclosure and then steps over and walks over to the rental property, knocks on the front door, and rightfully told the residents/tenants that they would have to vacate because the prior owner with whom they had a lease agreement has now been foreclosed upon, and that lease is terminated and their right of occupancy has expired and they have to leave. Those days apparently are gone. Now what will happen is that the purchaser through foreclosure would have an obligation and a duty to notify the existing residents and give them a notice to vacate, and since it's a month-to-month tenancy by statute, it will be a 30-day notice, unless the lease agreement had in it a provision whereby a notice of non-renewal had to be 60 days or 45 days or something of that nature. So the purchaser through foreclosure is going to have to consult either Virginia law and the lease agreement that has now been terminated to determine exactly what that notice period is and how to effectuate the notice. Now, of course, the buyer through foreclosure could also negotiate a new lease with the existing tenants, which is perfectly available to them. So they don't necessarily have to go to the step of seeking possession and seeking eviction of the existing tenants. If they wanted to, they could negotiate a new lease agreement with them and start a whole new landlord-tenant relationship that way. So that is a significant change, in my opinion, to the foreclosure procedures here in Virginia. The next one is not so much of a change as, to me, it's more reading like that it's just a confirmation of how these requests for possession are going to be handled on the commercial side. And that is number 3 of my outline, Virginia Code Section 55-217. Applicability, right to terminate tenant. What that basically is telling us is, in Virginia, residential leases, landlords have absolutely no right of self-help. The only way you would be able to regain possession of property, even if the tenant is in breach of the lease, is to file the appropriate notice, file the unlawful detainer if the resident refuses to leave at the expiration of the notice, and then obtain an order of possession through the court. The landlords here in Virginia on the residential side are not permitted to seek self-help, meaning they cannot change the locks, cut off the water, do any of those types of measures. They have to go through the court, have to give the appropriate notice, have to serve the unlawful detainer, and so forth. What 55-217 is telling us, though, is in non-residential cases, commercial cases, the right of self-help is still available, provided that it is, one, it's in the lease agreement. That remedy has to be made available to the landlord in the lease agreement. Appropriate notices have to be given in accordance with the lease. So in order to avail yourself of this remedy, the landlord will have to make sure that the various prerequisites are met. In other words, a breach has occurred, the appropriate notice has been given, and that the remedy of self-help is spelled out in the lease agreement. But assuming that that is in fact the case, then the landlord is permitted to exercise self-help in Virginia in commercial and other non-residential tenancies. The one caveat here or warning is that if the landlord is going to pursue a self-help eviction, they must do so in a way that does not incite a breach of the peace. But this amendment goes on to make it also clear that nothing shall be construed to preclude termination of any commercial or other non-residential tenancy by filing an unlawful detainer action, entry of an order of possession, and execution of the eviction process. So even though the self-help remedy is available to landlords in commercial and non-residential tenancies, they're making it clear that if you want to go to court, you most certainly have that available to you, and therefore self-help only available remedy there is. Typically, unless it's an extreme case, I typically follow the last procedure and go ahead and afford the tenant notice, and if they refuse to leave or they refuse to cure the breach, then we file the unlawful detainer action and we go through the court. I have, in 27 years of practice in this area, used and exercised the right of self-help, but it's been somewhat limited. Typically, I choose, as I said, the latter approach and involve the court system if we are seeking possession in a commercial or non-residential lease agreement. Now, number 4, Virginia Code Section 55-248.15:1, that is dealing with security deposits. The main amendment that I want to bring to your attention deals with the move-out inspection and how that is supposed to work. And that is somewhat of a timely amendment because there have been a number of cases that I have been involved in where the tenant was alleging that the landlord did not provide or allow for the tenant to attend their move-out inspection. And typically those claims arose when the landlord was seeking a claim for damages that exceeded normal wear and tear at the end of the tenancy. And the tenant, in a defense to those claims of damages, would argue that they were not permitted to participate in the move-out inspection, and therefore they were asking the court to deny the landlord those claims with regard to damages due to the fact that, or at least due to their allegation that they weren't permitted to participate in the move-out inspection. And then when you read the statute, it wasn't necessarily clear as to how that was to out, who was to give who notice and so forth. But now what they've done is they've revised it in the hopes of making this clear. And this is how it typically, this is how it should have worked, or usually it typically worked. They've tried to clarify it, and now this is the way it should play out. Either party, the tenant or the landlord, may give the other party a notice of non-renewal. The tenant is ready to leave. Many cases, let's go to a college town, for example, like Charlottesville or Blacksburg. The tenant is a college student, university student. Their tenancy is coming up. They're getting ready to graduate. They are no longer in need of this leased premises. And so they're going to give the landlord a notice of non-renewal to end the lease at the end of the current lease term. Or you have a situation where the landlord has decided to non-renew for whatever reason the lease agreement, and the landlord gives the tenant a notice of non-renewal. Now, the way that works, and what I have been advising my clients is that if the landlord is giving the notice of non-renewal, then that notice should have language in there that advises the tenant that they have a right to participate in the move-out inspection. Or if the tenant is the one who has afforded the landlord a notice of non-renewal, then the landlord should respond by acknowledging receipt of that notice, but also reminding the resident that they have a right to participate in the move-out inspection. Now, then what happens is somewhat like a tennis match. That's sort of the serve, if you will. The response is, or the return of that serve is that once the tenant has been advised of their right to participate and attend the move-out inspection, the burden then shifts to the tenant to advise the landlord in writing that they want to participate. So to start off, the landlord is going to advise or remind the tenant of their right to participate in the move-out inspection. Once they've been notified or reminded of that right, the tenant then has the burden of notifying the landlord in writing that they would like to participate in the move-out inspection or like to attend it, at which point, once the landlord has received that notice in writing, then the landlord informs the tenant of their right of the date and of the time in which the inspection will be held. Now, I do not read this amendment to say that the landlord and the tenant have to coordinate with one another in scheduling the date and time. Simply, the landlord, upon receipt of the notice from the tenant that they do want to participate and attend the move-out inspection, once the landlord receives notice of that, then the landlord simply notifies the tenant of the date and time in which the move-out inspection will be held, and it has to be held within 72 hours of delivery of possession, which in Virginia typically means when the keys have been surrendered from the tenant back to the landlord. So within 72 hours of the surrender of the keys, the move-out inspection has to be held. Then once the landlord has given this notice of the date and of the time of the move-out inspection, if the tenant shows up and attends, fine. If they don't, well, the landlord's going to go ahead and conduct the inspection, the move-out inspection. Now, once that has been done and the move-out inspection has been completed and the damages above reasonable wear and tear and any other amounts that the landlord claims to be due and owing, once that can be tallied up and totaled, then the landlord will apply that against the security deposit and then would notify the tenant within the statutory time period of how the deposit is applied. The landlord gives an itemized list of the damages, and that could be rent, late fees, that could be damages in the physical sense, meaning damages to the door, the walls, the carpet, the lock, doorknobs, etc. Landlord, however, is required to itemize these lists of damages and then show how the deposit has been applied, and then send that with any amounts left over of the deposit to the tenant within the required time period, which typically is, by statute, 45 days from termination of tenancy and delivery of possession. Now, once the landlord has done that, the statute goes on to say that there's nothing in the statute shall be construed to preclude the landlord from recovery of such damages against the tenant that may not have been found or discovered during the course of the move-out inspection. So if the landlord does the move-out inspection, cites or notes a number of different things, and then concludes the inspection, and then a couple of days later they come in and they discover that there was pet urine in the carpet, for example, that was not obvious or prevalent when they first did the inspection. Many times that's not going to be discovered until the carpet has been shampooed, for example. But if there's any after discovered damages that were not picked up during the course of the move-out inspection, nothing would preclude the landlord from seeking the recovery of those damages that had not been discovered during the course of the inspection. However, of course, is again sort of balancing the playing field. The tenant is permitted to present evidence, which would typically be the move-out inspection form, in support of the tenant's position that any additional damages that the landlord is now trying to seek that are not reflected in the move-out inspection did not exist at the time of the move-out inspection. So the way this would work is the landlord would conduct the move-out inspection, note any damages above reasonable wear and tear, then he or she would quantify the amount of those damages, and then also add up any unpaid rent, any late fees, any other costs or fees that may be owing. They're going to get a gross total security deposit against that gross total, leaving you with a net figure, or it could be that there was a leftover of the deposit. But once that's done, then that has to be sent to the former tenant, an itemized list with any refund if there was. If there's not a refund, they're going to show a deficient amount. Then once that's been done, if the landlord goes back into the apartment to get it ready to re-rent to someone else and discovers other damages that are not or was not discovered and noted on the move-out inspection form, the landlord is still permitted to seek those damages as well. But the tenant, of course, will then, if this thing goes to court, the tenant would be pointing to the move-out inspection and showing that these damages were not noted on the move-out inspection, of course, raising the argument that they did not exist at the time that the tenant turned over possession. Of course, then the landlord would be put to the burden of explaining why it had been discovered during the course of the move-out. Now, we will talk about the importance of move-in and move-out inspections later on in this presentation, but those were the changes, trying to make it clear how this back and forth is to work. Again, and then real quickly, landlord either giving the notice of non-renewal or receiving a notice of non-renewal advises tenant of his or her right to attend the move-out inspection. Tenant, in response to that, puts the landlord on notice in writing that they want to appear, want to attend. Landlord then responds saying, here's the date, here's the time, and it has to be done within 72 hours. Now, moving to the next one, number 5, Virginia Code Section 55-248.31. I had mentioned earlier about the immediate non-remedial violations, which we call really the 72-hour notice, those that are a direct threat to health and safety or an immediate threat to health and safety. The Section 31 had been revised or amended years ago to make it clear that any that involved drug activity would constitute an immediate non-remediable. Well, now what the General Assembly has done is made it clear that any activity, criminal or willful, that poses a threat to health and safety, whether it's illegal drug activity or not, would entitle the landlord to issue the tenant a 72-hour notice. Now, please note that the 72-hour notice, you're not going to find that reference in the statute. Traditionally, again, I've been doing this for 27 years, and there's just been somewhat of an informal recognition that if the resident commits a breach that is of an immediate threat to health and safety, again, an easy example is drug activity, they are entitled to an immediate non-remediable notice, which most of us have, again, informally recognized that it would be a 72-hour notice. Now, I've got a number of friends of mine who practice in this area who give a 24-hour notice or give or say an immediate is an immediate. So they don't necessarily feel like that they have to give a 72-hour notice because the statute doesn't necessarily say that. And I don't take issue with that. It just says that the resident is entitled to an immediate notice of a non-remediable violation. What constitutes adequate notice of an immediate kind? Again, informally, it's been accepted or recognized that it's 72-hour notice, but if someone gives a 48-hour or a 24-hour notice, I don't think that in and of itself would make the notice effective. But typically, what's given is what's called a 72-hour or 3-day notice. Again, the change for 31 is basically expanding what the courts would recognize as entitling the landlord to issue an immediate non-remediable notice. It now is, it had been rather illegal drug activity. Now it can be any activity. Most likely what I would say is if the activity or breach is of a criminal nature, then it's an immediate non-remediable. Now going to the last code section that we are talking about in this first segment, it's Virginia Code Section 55-248.38:3. That's when you have a sole tenant who has died and there was no other tenants on the lease agreement. This again, this statute has been on the books for a number of years, but they again ran into some confusion as to how it should work. For example, you have a tenant who had several occupants. They were not tenants, but they were recognized occupants on the lease. So the way the old statute read, it referred to the tenant as a sole occupant. And so there was questions around the legal community. Does that mean a sole tenant, or does that mean that if it was a tenant with several occupants, there's still some occupants left? Would this statute apply? So essentially what the General Assembly has now clarified is when we're talking about someone who is a sole occupant or now a sole tenant, it means if you look at the lease agreement and there was only one tenant on the lease, then they are the sole tenant, and should they die, then 38:3 will come into play. If there are multiple tenants, obviously, then 38:3 will not come into play because there are other people who still have a right of occupancy and tenancy that are not going to be necessarily affected by one of the tenants' death. But if you have a lease agreement with a sole tenant and no one else on the lease that is a tenant, then 38:3 is going to come into play. And if there happens to be an occupant or two who are recognized under the lease, who are living in the apartment, they are no longer allowed to occupy the dwelling unit after the death of the sole remaining tenant. And they are required to vacate the dwelling unit prior to the end of the 10-day period, which is the 10-day notice period spelled out in 38:3. So therefore, if you have a case where you have one tenant on a lease, and let's say there are 3 recognized occupants on the lease, authorized occupants, they're not tenants, they're just occupants. If that sole tenant should die during the course of the tenancy, then the 3 occupants have to vacate. And they are given 10 days, that 10-day period in which to vacate. Now, if they do not vacate, again, we cannot use self-help. You cannot force them to leave. They are not trespassers. The only way you're going to be able to have them removed from the tenants or removed from the lease premises at the end of the tenancy when the sole tenant dies, you'll have to give a notice and you'll have to file an unlawful detainer. Now, you may ask what kind of notice or should you give. Since they're not tenants, then you're not necessarily bound by the notice provisions under the VRLTA. If you want to play it safe, you could give them a 30-day notice, but I don't believe that necessarily is required. You could give them a 10-day notice as stated in this code section because it says that they have to get out at the end of the 10-day period. So I think at least they're entitled to a 10-day notice, or you could give them a 30. I mean, again, if you want to play it safe, especially if they were authorized occupants under the lease agreement. But the bottom line here is once that sole tenant dies, then any authorized occupants, guests, or invitees who are living in the apartment unit or in the leased premises, they will have to vacate. Their right of occupancy terminates at the time of death of the sole tenant. But again, remember, you're not permitted to exercise self-help. You'll have to go to the courts if they refuse to vacate at the expiration of that 10-day period. You will not be able to exercise self-help. That is the section 1 of the outline dealing with the recent amendments to the VRLTA.